Lord Legate will explain the decision of the Court.
This appeal raises a question about the scope of the environmental impact assessment that is required before permission may be given for a project to extract oil. Before planning permission can be given for a project which is likely to have significant effects on the environment, legislation in the United Kingdom and many other countries requires an assessment of the environmental impact of the project to be carried out. The legislation that applies in this case is contained in statutory regulations made in 2017, which implemented a directive of the European Union. Under this legislation, an environmental impact assessment, when required, must identify, describe and assess the likely direct and indirect significant effects of the project on the environment, including, among other factors, the impact on climate. For example, the nature and magnitude of greenhouse gas emissions. The process of assessment must include public consultation. The legislation does not prevent the planning authority from giving consent for a project that is likely to cause significant harm to the environment, but it requires the authority to reach a reasoned conclusion on the environmental impact and to take this conclusion into account in making its decision. In this case, a developer applied to Surrey County Council for planning permission to expand oil production from a well site at Hawes Hill near Hawley in Surrey. The proposed project would involve the extraction of oil from 6 wells over a period of 20 years. The project comes within a category for which an environmental impact assessment is compulsory: extraction of petroleum for commercial purposes where the amount extracted exceeds 500 tonnes a day. The developer argued that when it came to assessing the impact of the project on climate, the assessment should be confined to direct releases of greenhouse gases from within the well site boundary during the lifetime of the project, and that it need not include the greenhouse gas emissions that would occur elsewhere when the oil extracted from the wells is ultimately burnt as fuel. The Council accepted this approach. Its decision to grant planning permission for the project was therefore made without assessing or taking into account the emissions that would occur upon combustion of the oil produced. The claimant, a local resident, applied for judicial review of the Council's decision. She argued that the decision was unlawful because the environmental impact assessment should have assessed and taken account of these emissions. The High Court judge rejected the claim, holding that the emissions that will occur upon combustion of the oil produced were not within the legal scope of the directive and the statutory regulations. By a majority, the Court of Appeal upheld that result, but on an alternative basis. In their view, whether to assess these emissions was a matter for the Council's judgment, and the Council had given legally valid reasons for deciding not to do so. The claimant appealed to the Supreme Court. By a majority of 3 to 2, the Supreme Court allows the appeal. The majority judgment is given by myself, Lord Legate, with whom Lord Kitchen and Lady Rose agree. Lord Sales, with whom Lord Richards agrees, dissents. It is an agreed fact that if the project to extract oil goes ahead, it is not merely likely, but inevitable, that the oil produced from the well site will be refined, and as an end product will eventually undergo combustion, and that combustion will produce greenhouse gas emissions. It is not disputed that these emissions will have a significant impact on climate. It is agreed that the amount of these emissions can be estimated using an established method. Indeed, the Council has provided such an estimate as part of its evidence in this case. The issue is whether the emissions that will occur when the oil is burnt as fuel are direct or indirect effects of the project, within the meaning of the directive and the regulations. If they are, then they must be assessed. The Supreme Court is unanimous in rejecting the view of the Court of Appeal that this question is a matter of judgment on which different planning authorities could properly take opposite views. It is unreasonable to interpret the legislation in a way that treats inconsistent answers to the question whether the combustion emissions are effects of the project as equally valid, so that one local planning authority might decide that the regulations require such emissions to be assessed, while another local planning authority might decide that the regulations do not require such emissions to be assessed, without it being possible to say that either of them is wrong. The Court is therefore agreed that whether the combustion emissions fall within the scope of the environmental impact assessment required by law is a question that in principle admits of only one answer. But we do not agree about what that answer is. Lord Sales and Lord Richards infer from the general scheme of the EU Directive that the environmental effects that must be assessed are limited to effects on the local area where the project is situated. They agree with the judge that for the purpose of the legislation, the direct and indirect effects of the project do not extend to remote effects, such as the greenhouse gas emissions that will occur downstream when the oil produced from the wells is processed and used. I will not go into more detail of their reasoning, not through any lack of respect for their view, but because the purpose of these brief remarks is to summarise the reasons for the decision which the Court has reached, in this case by a majority. The majority of us do not accept that the scope of the assessment is limited in this way. The Directive and the regulations state in terms that the environmental impact assessment should cover not only direct effects of the project, but also, quote, any indirect, secondary, cumulative, transboundary, short-term, medium-term and long-term, permanent and temporary, positive and negative effects of the project. It would be hard to devise broader wording than this. Whether a particular impact on the environment is an effect of the project is a question of causation. In this case, there is no uncertainty about the relevant facts. It is known with certainty that if the project goes ahead, the activity of extracting oil from the ground, for which planning permission is sought, will initiate a causal chain that will lead to all the oil extracted being burnt as fuel and releasing greenhouse gases into the Earth's atmosphere. On the agreed facts, this chain of events and the resulting effects on climate are not merely likely, but inevitable. The greenhouse gas emissions that will occur on combustion of the oil produced are therefore, in our view, straightforwardly effects of the project. The Directive does not impose any geographical limit on the scope of the environmental effects of a project that must be assessed. The Council was therefore wrong, in our view, to confine the scope of the assessment, in this case, to direct releases of greenhouse gases that would occur at the project site. It is in the very nature of indirect effects that they may occur away from the location of the activity which causes them. Notably, too, the impact of greenhouse gas emissions on climate does not depend on where physically the emissions take place. Wherever greenhouse gas emissions occur, they add to the levels of greenhouse gases in the Earth's atmosphere and contribute to global warming. There is no correlation between where greenhouse gases are released and where climate change is felt. The judge considered that the emissions occurring on combustion cannot in law be regarded as effects of the project because what is burnt as fuel will not be the crude oil produced from the well site, but an end product made at a separate facility where the oil will be refined for use as fuel. We reject this argument. The process of refining crude oil does not alter its basic nature or its intended use. The whole purpose of extracting oil from the ground is so that it can be used as fuel. In these circumstances, the fact that oil, unlike, say, coal, must undergo an intermediate process before it can be used for its intended purpose cannot reasonably be regarded as breaking the causal connection between the extraction of the oil and its subsequent combustion. The judge was concerned about the implications of this conclusion for other types of project. For example, a project to produce a raw material such as steel, which is then used to manufacture parts for use in making motor vehicles or aircraft. If the greenhouse gas emissions that will result from the use of the motor vehicles or aircraft were regarded as indirect effects of the production of the steel, the requirement to assess those effects would be unduly onerous and unworkable. The majority of the Court considers these concerns to be misplaced. Raw materials such as steel can be put to many possible uses, and the view might reasonably be taken that no meaningful assessment or estimate can be made of what emissions will ultimately result from its use. Oil is a very different commodity. There is no element of conjecture about what will ultimately happen to the oil. Unlike the incorporation of a part in a motor vehicle or aircraft, refining the oil does not change it into a different type of object, and a reasonable estimate can readily be made of the emissions that will occur upon its inevitable combustion. We also reject an argument that national planning policy is relevant to the scope of the assessment. The UK's national policy of encouraging domestic production of oil and gas is relevant to the decision whether to grant planning permission for the project, but it does not dispense with the legal requirement to assess the environmental impact of the project or justify limiting the scope of that assessment. The environmental impact assessment must still ensure that whatever the decision taken, it is taken with full knowledge and public awareness of the likely significant environmental effects. We conclude that the Council's failure to assess the effect that burning the oil to be produced from the well site would have on climate means that its decision to grant planning permission for the project was unlawful and must be quashed.